Hello, folks. It is Friday. It is a consumer. The day or week or even month in in some parts of the world between your Thanksgiving and Christmas season. We have all the stores who raised their prices 2 weeks ago are now back to normal prices but claim they are on sale. That's about it, isn't it? Black Friday. But we are here. We are here. We are not slightly buzzed. Not yet. Not yet, at least. I have. People keep telling me you need to drink something other than alcohol. I do. Beer. But all right, all right. I know what you mean. I know what you mean. But it is officially Christmas season. Okay? Okay. Let's go with it's officially Christmas season. I waited. I waited for so long. I have waited for way too long. Way too long for this. Oh, where? Oh, and I have. Where is that? Oh, look at that! Hey, it's Santa Claus. Now, where is that one? Or did I remove it? I don't know. It should be. Oh well. Oh well. I will find it to next time. Oh, wait a minute. It's officially Christmas season. It's official. Now, the background will switch more and more. I will add some things. For instance, I have these shiny candy cane things, but ran out of battery. So I will add a few things here and there to make everything more cozy. And of course, we have the first spam bot over at Kick. Banned. Okay. Done. Again, people who create spam bots, program spam bots, sell spam bots, and buys spam bots, nobody will ever miss you. Okay? Nobody. You are on the naughty list. Spam bot, programmers, sellers, buyers. You are all getting coal in your Christmas stocking this year. But all right. Let's get into some more interesting things like you guys. Let's see. Gwendolyn, Coke Fairy, True Crime Addicted, Carolina, Melissa, DK Cripple, Zimi Mads, Paladin, hello, M11969, good evening, Neo Dark Matter, good evening, and hello, folks over at Kick and Rumble. Because, of course, we have to diversify the streams. Diversify. I think that's what it's called. All right. Denise Sells is here. All right. What do you want to start with? I have Randazza Letters. I have the thing with where a trooper Proctor claims, I don't have a lawyer. Folks, Proctor claiming, I have no lawyer, you can go down to a strip mall and hire one who doesn't care. Now, why does he claim he doesn't have a lawyer? Well, of course, it is because Karen Reed, in the civil suit, where everybody sues each other, they want the discovery. And former Rupert Proctor does not want to share, so he's stalling. Now, this might work if you have Judge Bev to help you and the prosecutors in the criminal trial. This is civil trial or a civil case at the moment. New rules. Yeah. And for instance, I mean, you can postpone. I mean, there's always techniques and things to postpone things, but not indefinitely. Not indefinitely. And by the way, I bought a new whiskey. Clan McGregor. I saw it at the liquor store and I thought to myself, yep, going to take that one. Because the things I bought in the United States when I went there in September is, well, we still have plenty. We still have plenty, but I need to restock them. Yeah. Bev is off criminal and back on civil. Imagine if she ends up in charge of Karen's civil suits. Oh, I don't think so. Especially since the McAlberts now wants to do this in federal court. Then it will be really interesting. Oh, Squid Pro Quo! I got raided. Raided! Thank you so much. Thank you so much. Hello, folks over from Squid Pro Quo. Now, if this goes over the Karen Reed trial, hold on, I need to grab myself a brew of choice, which is Hazy Bulldog Pale Ale. That's So let's get this buzz in the Slightly Buzzed Friday show on the go. Yeah. The McAlberts might think that, yeah, if we go to federal court, we won't be on TV. Well, no, the proceedings won't be streamed. But that only means we can be more inventive with the McAlberts and the filings and the stuff and the things and folks, when I read from the Delphi trial as Arthur Holman, Jerry Holman's third cousin removed by inbred marriage, you know what I do. I put on a mask and I do a funny voice. Now, can I do that with all the McAlberts? Sure. It can be very interesting because this case won't go away. Even if it is probably a couple of years away, we McAlberts, McCabe, Alberts, Buchanan, the rest of you. Are you sure you want our imagination to run amok? Well, yeah. Oh. But, well, since we are already talking about it, let's read the thing. No, darn. Oh, hold on. Where did it go? All right, there it is. Hold on. Let's download it instead. Oh, there. There you go. There you go. And let's make this a bit bigger. And let's put myself in this corner. So, yeah. Okay, let's go. And a mistletoe border. Of course, of course. Oh. Ho, 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 says Santa Claus. Oh. Ooh. The elf. Well, sort of. It's a moose or reindeer. Something, yeah. All right, let's go. Memorandum of law in support of motion to compel Michael Proctor to produce documents pursuant to subpoenas. Defendant Karen Reed respectfully requests that the court compel former Massachusetts State Police Trooper Michael Proctor to produce documents due as long as 3 months ago. Yeah, idiot is 3 months late with producing the documents that he is obligated to share. He has no choice in the matter. Reed served a subpoena on Proctor in hand in July 2025. Reed also served a second subpoena seeking a discrete set of additional documents in October 2025. Proctor acknowledged receiving both subpoenas and requested repeated extensions to respond. However, Proctor has failed to meet all new agreed-to deadlines and has not substantively responded to either subpoena or produced any documents. The court should compel him to do so. So, he agreed to deadlines and then didn't. Yeah, obligations, schmogligation. Facts. Plaintiffs alleged that Reed backed her car into John O'Keefe III on January 29th, 2022 and caused his death. They also alleged that Reed created a false narrative that someone else killed Mr. O'Keefe and that the police investigation into his death was corrupt, biased, and designed to deflect attention away from the law enforcement officers and their families who were inside the house at 34 Fairview Road in Canton the night Mr. O'Keefe died. Plaintiffs claim Reed's assertion of this alleged quote-unquote false narrative supports their negligent, reckless infliction of emotional distress claims against Reed. In an effort to defend against plaintiffs' claims by, in part, proving that this narrative is actually true, on July 23rd, 2025, Reed served the first subpoena on Proctor by hand. Proctor led this investigation into Mr. O'Keefe's death, which led to Reed's arrest and prosecution. He is central to the narrative on which plaintiffs rely. The first subpoena requires Proctor to appear for deposition. Uh-oh. Michael, Proctor, have you ever been deposed before? Well, you might have been as a cop. You're no longer a cop, and you don't have the police union with you. Oh, oh. I want that recording so bad once he gets deposed. And seeks various categories of documents, including all documents and communications concerning Reed. Mr. O'Keefe, the investigation into Mr. O'Keefe's death, other potential witnesses and suspects, and other relevant topics. Footnote 1. A true and accurate copy of the first subpoena include... Okay, so it's... yeah. The first subpoena required Proctor to produce these documents by August 5th, 2025. On July 28th, Attorney Daniel Moynihan, Proctor's counsel in his administrative appeal of his termination from the Massachusetts State Police, contacted Reed's counsel, stated that he was confirming that his office would represent Proctor in connection with this case, and asked Reed's counsel to continue the deposition and wait a week before settling on a new date for the production of documents. Reed's counsel agreed, but Attorney Moynihan did not follow up and did not respond to further emails from Reed's counsel on August 27th or September 11th. On September 15th, Reed's counsel sent a letter to Attorney Moynihan's office demanding a response. The next day, another attorney from Attorney Moynihan's office, Mark Russell, responded to Reed's counsel. Attorney Russell indicated that his firm had not been retained to represent Proctor in connection with this case. How about that, folks? It appeared they were just a couple of weeks prior, and all of a sudden, they're not. And did not propose any new deadline for Proctor's response to the subpoena. Gwen, wouldn't they need those documents so they could question him about it? Exactly. They need not only to depose him, but they need his documents. All the things. Personal documents. His cell phone. All the things. All of it. In order to depose and ask about the facts of the case. What he officially said. And what he did privately. Reed's counsel followed up multiple times to clarify if attorneys Moynihan and Russell's firm was authorized to speak on Proctor's behalf in connection with the subpoena. Ultimately, Attorney Moynihan stated the firm was not, and claimed he was only trying to facilitate a response. This here, folks, is really bad, because if he claims he was only trying to facilitate a response and he wasn't actually representing, as an attorney, you have an absolute obligation to disclose if you're the active attorney in the case or not. It's not the time to be vague. So this attorney's conduct cost the Reed defense weeks of time they could have tried to contact Proctor privately. Because if you have representation, you contact the party's attorney. All this time, when they tried to get a hold of Moynihan, they should have contacted Proctor himself privately, since he was not represented. So this is on that firm. Reed's counsel explained that he needed to confer with counsel who actually represents Proctor in connection with the first subpoena to see if the parties could agree to a new production deadline and avoid motion practice. No new counsel appeared, and Proctor did not produce any documents or written response to the first subpoena. Hello, Mr. Beardy, says Miss Pottage. Hello. Good to see you. On October 22nd, 2025, Reed served Proctor with a second subpoena, Exhibit 2, which relates only to documents concerning certain disclosures made to Attorney Moynihan the previous week by the Norfolk District Attorney's Office, and Proctor's decision to abruptly withdraw his administrative appeal as a result of these revelations. The second subpoena was left at Proctor's last and usual address. Hey, Danny. Ho, ho, ho. Yeah. Attorney Moynihan is the union attorney. And they sped off into the night after learning what Proctor actually had in his phone. Oh, they ran so fast their shadows didn't catch up until a week later. Yeah, Proctor is used to Lally levels of follow-up, not basic levels of follow-up. Yeah. After receiving the second subpoena, Proctor called Reed's counsel directly on October 24th and left a message. They spoke on October 27th. During that call, Proctor confirmed that he was not presently represented by counsel and explained that he needed more time to produce documents because he was in the process of finding counsel. This is October 27th. His first subpoena was in July. They fucked off as his attorney in September. Do you know how quick you can get an attorney? You bring out your phone, you Google attorneys near me, civil attorneys to practice in the area, and you get a bunch of Google results. Then you call them one by one until you get one you can afford and is willing to represent you. If you're slow in your head, mentally challenged like Michael Proctor, or simply like Michael Proctor probably does, I need to avoid this, let's punt it forward. Even if you're really, really slow, it takes maybe half a day. Proctor has done fuck all for 3 months. When I Google attorneys near Nick, I get a bunch of Swedes. Oh, Proctor piss off all the attorneys in the state. There are always attorneys ready to take a case, even with the most vile people. There will be attorneys taking the case. Always. It's not like you have a shortage of attorneys in the United States, okay? All right. Reed's counsel explained that it had been months since Proctor had received a subpoena and that Reed would move to compel production if Proctor did not agree to an acceptable date by which he would produce documents. Proctor asked Reed's counsel not to serve such a motion that week to allow Proctor to engage counsel. Reed's counsel agreed, and Proctor said his new counsel would reach out by October 31st. No new counsel appeared for Proctor by that date. Indeed, as of the date of this motion, no counsel has appeared for Proctor. And folks, as I said, half a day tops, and he would have an attorney. Tops. Call 5 attorneys, compare prices. Are they willing to represent you? Done. Instead, Proctor called Reed's counsel again on October 31st and said that Reed's motion to add parties, which had been served in the interim, had caused the attorney he planned to hire to refuse the engagement. Proctor asked for even more time. Reed's counsel explained that he could not agree to further delays where the documents in question had been due 3 months earlier. Proctor has not objected to either of the subpoena. This is just stupid, folks. This is just stupid. Now we have half an hour in, and just so you know, the wheel of regrets is at play. The wheel of regrets is at play. Let's see here. Dun, dun, dun. Dun, dun, dun. Let's show it. This is the wheel of regrets. And as the banner says, individual supers, gifted memberships, PayPal, and buy me a coffee of $50, and you can say what I drink. A combined $50 gets a spin on the wheel. That is the rules of engagement. Welcome to Slightly Buzzed Friday show. All right, let's get back to the thing. Analysis. The court should compel Proctor to produce all documents and information in his possession, custody, or control that are responsive to the subpoenas. The subpoenas seek potential evidence that would be highly relevant to the truth of the alleged false narrative plaintiffs rely on for their emotional distress claims. Proctor led the investigation into Mr. O'Keefe's death for the Massachusetts State Police and was primary focus for the allegations and statements Reed made, which plaintiffs claim caused them harm. Specifically, Reed has alleged that Proctor deliberately ignored, manipulated, and falsified evidence to direct the investigation away from other potential suspects and towards Reed. It is vital to her defense that she be permitted to, among other things, prove that such allegations were true when she made them, and Proctor's documents are directly relevant to that point. Therefore, they are all well within the scope of discovery. Hey, Sneeds! Sneeds over at Cake. Good to see you. Good to see you. Let's see. Good to have you here. Good to have you here. Although Reed cooperated with many of Proctor's requests for extension to avoid the need for motion practice, it has been 3 months since the vast majority of the documents were due, and Proctor has not committed to any deadline for production and is not, to Reed's knowledge, currently represented by counsel with whom Reed's counsel can confer. Therefore, the court should order Proctor to comply with his obligations and produce documents. Conclusion. For the foregoing reason, Reed respectfully requests that the court allow the motion and compel Proctor to produce all documents and information responsive to the subpoenas within 10 days after the court's order. Now, this here, now when the McAlberts wants this into federal court, it might be that the judge in state court will punt this until that is decided. But then again, remember, folks, the McAlberts, in their motion to punt this to the federal court, said that everybody was in agreement of the parties. Well, they also claimed that Proctor was in agreement. Well, Proctor hasn't spoken on that issue. So how did they know? He doesn't. He's not. Maybe he doesn't have a lawyer. Does not have a lawyer. Ah, thank you, Paladin. I bet you there's lawyers calling him asking to represent him. Just for the worldwide free public attention. Oh, definitely. Definitely. So it's just Proctor is just stalling, folks. That's all it is. Respectfully submitted. Can read by her attorneys. Damon, Shaw's, Aaron, Alan, Caleb, Elizabeth. Certificate. Exhibit 1. Subpoena to Michael Proctor. Greetings! You're hereby commanded in the name of the Commonwealth of Massachusetts, pursuant to provisions of Rule 45 of the Massachusetts Rule of Civil Procedure, to produce the documents identified in the attached Schedule A at the offices. Yeah, blah, 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 blah. You're further commanded to appear at the offices, blah, 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 and to testify as to your knowledge at the taking of a deposition in the above entitled action before a notary public. Yeah. So that was August 28th. We are now November 28th, a month later, and Proctor does fuck all. And schedule, blah, blah, blah. Okay. Let's see here. Definitions, instructions. Documents withheld. If any documents is withheld under a claim of privileged or other protection, so as to aid the court and the parties hereto to determine the validity of the claim of privilege or other protection, please provide the following information with respect to any such documents. Yeah, it's not like he can say, oh, it's privileged. He has to do all of these things. So it's just not that he can try. It won't work. Hey, Erin. Hey, Erin. Good to have you here. Document request. Document request from Trooper Proctor. All documents, video or audio recordings, and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning Karen Reed or any of her family members, heirs, assigns, employees, contractors, agents, attorneys, or other representatives. All of it, Mr. Proctor. All of it! All documents, video or audio recordings and communication, including but not limited to email, blah, blah, yeah. And other forms of instant. Concerning the Lexus, the death of John O'Keefe. This is interesting. All documents, video or audio recordings or communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning John O'Keefe II, Paul O'Keefe, or Margaret O'Keefe. Yeah, what did he actually say to the O'Keefe family? What did he text them? What did he email them? That can be really, really interesting. What did he actually claim to them to make them absolutely immune to basic facts of the case? How they and others ignored middle school physics. All documents, blah, blah, blah. This is interesting here. all documents and everything concerning Brian Albert, Nicole Albert, Chris Albert, Julia Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Alison McCabe, Carol Roberts, or any other individual present at 34 Fairview Road, Canton, Massachusetts on January 28th or January 29th, or any interviews, meetings, conversations, or encounters with any such individuals from January 1st, 2021 to the present. Hey, Deanne, stopping by to say hi. Hello. Hello. Another interesting. Provide for forensic examination and copying all cellular or smartphones, computers, tablets, smartwatches, GPS devices, motor vehicle navigation system, or other electronic devices that record their location or can facilitate communication of any kind, which you used, as in Proctor, either personally or professionally at any time from January 1st, 2021 through the present. They want to know where he was. That can be interesting because remember, folks, he didn't drive. What was? Did it? I don't think he drove his squad car to a lot of places in this case. He used his personal car. Isn't that interesting? And when he did use his squad car, he turned the tracker off. He turned it off. OFF off. Why? Then you can lie. Where you been and when you were there. Yeah, so they're really going through everything here. They are thorough. Really, really thorough. And here is the Exhibit 2. Well, this is he who served Proctor. Affidavit of service. Yeah, I did the thing. Exhibit 2 is the second subpoena. Greetings! You're hereby commanded. Blah, 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 blah. In the name of Commonwealth of Massachusetts, pursuant to provisions of Rule 45, to produce documents identified in the attached Schedule A at the offices of la 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 la. So this is a second set that they want him to produce. And he hasn't done either. And then definitions. If he doesn't want to, here are the things he has to answer. And let's see here, documents request. All communications with or concerning the Norfolk District Attorney's Office or any employee, agent, attorney, or other representative of that office from July 1st, 2025 to the present. What, folks, what have they dug up on Proctor regarding this year, from July 1st to present? They read between the lines. They know something. They just need it confirmed. All non-privileged documents and communications relating to the recent disclosure. Brian Moynihan referenced the media reports about why you withdrew your appeal of your termination from Massachusetts State Police. Yeah, they withdrew after they found out what was in that phone. And I've been through it. In a separate video, how much it takes for the police union to abandon a cop. The police union, they will defend rapist cops. They will defend corrupt cops. They fucked off from Proctor so fast their shadows didn't catch up until a week later. What's in that phone? And here's the second person, and how he served the subpoena. So yeah, reading between the lines, something happened that, in my interpretation, Karen Reed's civil defense knows something. They just want it confirmed. What it is, don't know. But it's bad enough for the police union to abandon him. What's in the phone? What's in the box? What's in the phone? Whatever it is, it's really bad. Really, really bad. And thank you. Yeah. With Deanne and Paladin, we are now $40 away from the next spin on the Wheel of Regrets. Now, how much trouble is Proctor in? A ton. Because in civil court, you keep the judge up to date all the time. So now when they make the court aware of Trooper Proctor and his stalling, how he tries to punt it forward, how he claims he can't get representation. He gets representation. I mean, as I said, half a day. And even if he actually had an attorney who then fucked off, call the next one. Drinking cider? No, I'm drinking this. Hazy Bulldog Pale Ale. It's an American Pale Ale. Right after the second trial. The second trial, wasn't that done in April? When was the second trial done? No, okay. June 2025. So now they want from July 1st. And they want it. All this boils down to give us the phone and everything. Give us the phone. Yeah, Proctor. There really isn't much he can do about it other than hope that, for some odd reason, that the feds and their stipulations on what they found out somehow will protect him here. I don't think so. Because what's in his phone wasn't revealed. The extent of it. I mean, parts of it we knew, but the extent of it didn't show up until he tried to get his job back. And I don't think the Fed stipulation covers all of that. He can claim mental defect. No. Plot twist. Brennan represent Proctor pro bono. Oh. No, I don't think Brennan will touch this case again. He got paid handsomely. And then he's off. He really, really, really fucked off. Oh. I'm waiting for guests, by the way. I sent out an invite. Now, I know it's Black Friday, it's Friday. It is now close to midnight where I am, but it's only close to 6 where you guys are, most of you. So I understand why some guests can't. Dave, let's see if I got any replies. Dun, dun, dun. Oh well. So far, it's you and me. It's you and me, guys. Now, with the talking about Proctors, it will be interesting to see what the court says, which they should have a ruling either that, yeah, compel, or let's wait for the feds, or the federal court. So we just have to wait and see, as so much other things in this. And it will be really interesting to see how it transforms going forward. If the courts say, yes, let's put everything together in one big glorious trial where everybody's in. Or if they decide to separate it. No, it's up to the federal court, because since Karen sued under 1983, that's a federal statute. It should be in federal court, but the federal court can also say no, sending it back to state court. Thank you, Gigi. Thank you all for being here and tapping that like button. Yes, folks, have you done the thumbs up yet? It's all you have to do. All you have to do. Any gaming streams planned? No, I'm trying to learn OBS so I can get it all together, because apparently StreamYard, if I just put the game up and me up, it only produces sound from one of them, which is stupid. Oh, let's pin that. Feed the Swede, yes. If you don't want to sponsor YouTube, you can choose either PayPal or Buy Me a Coffee. PayPal is pinned on the top of the chat. And not yet. All right. You know what? Let's break off with a Randazza letter. This is from this year. It already made some rounds on social media, but I haven't seen it yet. So, via email only. Response: notice of non-compliance with Julia whatever's demand. Dear Mr. Redacted, we serve as First Amendment counsel to the owner of the X account, Murray Hill Guy. Your client, Julia, redacted, agreed to a date with my client. She then asked him if he voted for Zoran Mamdani, implying that it mattered in the context of the date. And my client's response was to cancel the date and to post the exchange on his social media account. A few people laughed. That should have been the end of it. Instead, Julia then activated total batshit mode, threatening to call the police on him for tweeting out the interaction. That and that he, quote, would be hearing from her lawyer. I guess that you're the backup to that threat. In operative part, your demand states, we are reaching out regarding recent online posts and content that have referenced or appeared to reference our client, either directly or indirectly. While we understand the nature of social media commentary, certain representation may be construed as defamatory or damaging to our client's reputation and well-being. If the material remains online, we may need to consider further legal remedies. I sense by the tenor of your demand that you don't entirely believe in it yourself. I suspect that your conversation with Julia went something like, Julia, there's nothing you can do about this. Are you out of your fucking mind? Then something, other than conviction in the ideas expressed, convinced you to say, fine, I'll send this stupid demand. I'm sorry, bro. I get it. Sometimes you just get stuck in a situation. I'm going to take your threat literally. That if my client does not remove this content from his social media, you're going to consider further legal remedies. You'll consider them, then realize that every one of them is fucking stupid. Then that will be the end of this. Or you can escalate this, and we can make you look even dumber. Your move. Sincerely, Mark Randazza. C.C. J.M. Wallman, President, Third Amendment Lawyers Association. Are courts overseas filled with this much drama as Massachusetts? No, not really. Our courts over here are very, very closed off. For instance, over here in Sweden, if I want to know about a certain case, I have to be there physically in the courtroom and take notes. Then, but if I want the entire transcript, I can't apply for it until after the trial is done. Then they have to make an assessment on how much, or if at all, they will send the transcript to me. And then I have to pay for it. So, yeah. So more or less from trial ending to when I can actually get the transcript, a few months. And by then, nobody's interested. Nobody's interested. Now, a little bit more Mark Randazza, because this is Mark Randazza. This is not an actual letter. This is him. Oh, hold on. Nope. Okay, like that. This is of course. Thank you so much for. Yeah, $50 is $50, and with $50 you get to decide. And mispronounced name says a delicious malort. Small batch handcraft from Barsebäcks Bränneri, which is the location of a now defunct nuclear power plant. Because why not? All right, let's see here. I'm taking this one. This. Nick's bar. Oh. Jesus. Cheers. Oh. Oh. Why? Oof. I don't know why people. I mean, there are certain alcohols that are, oh, it's smooth. It warms your soul. And then you have this, which are, no, why? 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 Who? I mean, I understand like 100 years ago, bad alcohol, a bunch of herbs made it less dangerous. But I mean, nowadays, but then again, it's entertainment. Oh, all right. Paint thinner and seafaring. Oh, but thank you so much. Thank you so much for your support of this channel. All right. Mark Randazza, I'm going to teach us a little bit about, I assume, his thought process behind the letters. The I declare confidentiality. You remember that episode where Michael Scott declares bankruptcy? Keep that in mind for this lesson, kids. This happens to all of us from time to time. A lawyer sends you a letter with some threatening language on it that he thinks accomplishes his goal of making it confidential. You know, like this. Confidential legal notice! Publication or dissemination is prohibited. Yeah, folks, even I know that's bullshit language. It's oh. The correct legal response is suck my ass. Or whatever you want to say. Okay, fine. How about your point is invalid? Let's go with that. It is nicer after all. And I'm all about being nice. Now, here's one thing you can rest assured of. If someone puts that foolishness on their letter, it is because they're afraid of that letter getting out there. They can't possibly have confidence in what's in it. Look, I write a letter. I expect that it might wind up getting slapped on Simple Justice with Greenfield making fun of it. Even then, I can't seem to catch every typo. But you know what? If my name's on it, you can bet your ass that I'll own it. And here's why you can make the shuckle fuck who signed your letter own it by publishing the shit out of it, if you want. For starters, saying this letter constitutes confidential legal communication and may not be published in any manner is about as legally compelling as Michael Scott yelling, I declare bankruptcy! Lawyers do not have magic powers that turn letters into confidential communications. You're more likely to find a lawyer who can turn water into funk than a lawyer who has the magic spell to make a letter confidential. Sure, there might be some rules that make them inadmissible for certain purposes in litigation, but you want to share that letter? Go right the fuck ahead. Unless you agreed to confidentiality, it ain't confidential. When I get one, I usually email the other guy and say, I'm not going to respond to your request for confidentiality. I give them a chance to support their position. When they don't, I ask them if they want to give me something in exchange for confidentiality. So far, no takers. Then they realize, holy flaming peckballs, this Randazza character can see right through this I declared confidentiality trick. Randazza has spell capability. Fuck! He's not a fighter. He's a goddamn level 9 ranger. And he's got druid spells. He just cast the see-through bullshit spell. So then they try again. Aha, smartass. That letter is copyrighted. I hereby throw the spell of Title 17. Bush League shit. If someone puts that on you, they're even more full of shit than the guy who just tries to I declare confidentiality spell. Dumbbells rolls a 2. Here's why. It is no secret that the film The Peoples vs. Larry Flint is one of my favorite movies of all time. It was required viewing in my classes back when I did law professor's thing. New hires need to watch it at my firm. You need to watch it. And I agree. The Peoples vs. Larry Flint is a landmark free speech case. Landmark. And the movie is good. Really good. Mr. Jingles is here. Hello, Mr. Jingles. Are you doing okay? Doing okay? Oh, hello, Mr. Jingles. Hello. Folks, I'm cuddling with my cat here, so hold on for a minute. Mr. Jingles is the actual owner of this channel, if you didn't know. Nothing goes through this unless Mr. Jingles approves of it. Better than Cousin Vinny? Well, two different kind of movies. Two different kind of movies. All right. Ow. Most of my readers are fully aware of the Supreme Court case depicted in the film. However, the lesser-known case, mentioned for all of 30 seconds in the film, is the Hustler versus Moral Majority countersuit. Oh. In that case, Jerry Falwell took the Jerry Falwell Talks About His First Time Campari parody and sent it to his Moral Majority minions, soliciting donations. Falwell took the entire copyrighted work and used it for blatantly commercial purpose. One of Falwell's top executives conceded that the inclusion of a copy of the ad parody was part of a marketing approach to fundraising. And the court can safely assume that this strategy involved encouraging the faithful to donate money. Hustler versus Moral Majority, 606, blah, 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 CD California, 1985. However, the court also found that he was not using the ad to elicit support for purely commercial gain, but even if he was, this did not dissolve his fair use defense. The court must also consider whether the alleged infringers copied the material to use it for the same intrinsic purpose for which the copyright owner intended it to be used. A lot of cases here. Fair use generally sustained if defendants use not in competition with the copyrighted use. Under this principle, defendants' use is more likely to be considered fair if it serves a different function than plaintiffs. That is really important when it comes to another case I cover. Hidden true crime and Lauren Matthias doing copyright claims on channels and people for criticizing her. One of the prongs in fair use is, does it take away... I don't claim to be a copyright attorney at all. I mean, I really, really don't. But if you don't have the same audience, if you add or remove things to make it an intrinsic... No, what's the word I'm looking for here? If you make changes, ever so slightly, Now, it's still up to the court to decide if it's fair use or not. But, for instance, Lauren Matthias is suing the relative of murdered kids for using, because here's the thing, that person gave Lauren pictures. Lauren made a collage of them that played a bit, which in that case gets that, yes, now her thing, how she put all of that together, that can be copyrighted if she ever did it. Now, then this person used this as a background while discussing the thing. Now, copyright in that extent, yeah, Lauren might have a case, but it's not guaranteed. And even if she had, Lauren, twat, shithead, you fucking loser, you're suing the aunt of murdered children about pictures you got and just arranged in a specific way. Folks, when we talk about grifting, most of us say it in a playful manner, but grifting, its original thing, is people doing bad shit for money. Lauren Matthias and Hidden True Crime are the original definition of grifters. They don't give two shits on a straw who they hurt, as long as they can make a buck on it. We will talk more about Lauren Matthias later in this stream. All right, let's continue reading here. It was interesting because I didn't realize this here was connected somehow to the Lauren Matthias crap. In distributing, the parody Falwell evidently meant to provoke the anger of his followers and to comment on the level of obscenity in the work. The city of California also pointed out portions of the Copyright Act's legislative history, upon which a reposter of a demand letter can rely. The court discerns additional support for Falwell's position in the legislative history to Section 107. The House report states, quote, when a copyrighted work contains unfair, inaccurate, or derogatory information concerning an individual or institution, the individual or institution may copy and reproduce such parts of the work as are necessary to permit understandable comment on the statements made in the work. Roughly translated to, if you have a thing and somebody else does a parody, satirical changes to it, then you, according to that case, can use it to make corrective commentary. That's my interpretation. But again, don't trust me on that one. I don't do copyright law. Yeah. Accordingly, when a law firm sends you a cease and desist letter accusing you of illegal activity, you can use that letter to provide your own supporters with copies of it in order to effectively give your own views on the issue and to gather support for your case and to make fun of that shit. Because making fun of buffoons is classic fair use. Now, that's a much better explanation. The legal landscape for I declare confidentiality gets even more gloomy as we continue to read the Hustler case. The First Amendment rears her sexy, putty, slutty face. This is his words, not mine. Yes, I want to ban Lady Liberty. It's a fetish. Constitutional cosplay, anyone? Oh. Oh, Randazza, you need to go to a cosplay convention. I can guarantee someone in there is doing Lady Liberty. And if you're lucky, you too will do Lady Liberty. No, Nexus, I will not repeat that sentence. I understand it might be clipped. Jesus. First Amendment considerations also enter into the court's assessment of the purpose and character of defendant's use. Although the First Amendment does not provide a defense to copyright infringement when an act of copying occurs in the course of a political, social, or moral debate, the public interest in free expression is one factor, favoring a finding of fair use. See Thompson Governor Committee versus Citizens for Gallin Committee, blah, blah, blah. Political committees' use of a portion of rival candidates' composition amounted to fair use in light of public interest in full debate over election and absence of injury to plaintiff. The Robert Stibbett Group versus O'Reilly. Priests' unauthorized copying of rock opera Jesus Christ Superstar was not fair use where facts did not support defendant's contention that the performance of counterattacked original's perverted version of the gospel. Similarly, anyone who receives a cease and desist letter from any lawyer, including me, can certainly claim that there is a debate at hand. Without the debate, there would be no complaint of statements or actions. It does not take Justice Brennan to see the First Amendment protection inherent in the republication of a demand letter in this context. Quote, the purpose of copyright is to create incentives to create creative effort. Even copying for non-commercial purposes may impair the copyright holder's ability to obtain the reward that Congress intended him to have. But a use that has no demonstrable effect upon the potential market for or the value of the copyrighted work need not be prohibited in order to protect the author's incentive to create. The prohibition of such non-commercial uses would merely inhibit access to ideas without any countervailing benefit. Sony Corp versus Universal City Studios from 1984. Under the harm to the market for the original prong of fair use, if defendant's use would tend to diminish sales of the plaintiff's work, then the factor can count against the defendant. However, that only applies if it would supplant the marketplace for the original. For instance, if I copy the demand letter and use it as my own, then I might be committing copyright infringement. On the other hand, if I use the demand letter to ridicule the author, and the result of that ridicule is that consumers form the opinion that perhaps it would not be a wise choice to select that lawyer to represent him, that is protected speech. And with the Laura Mathias against the relative of the murdered children, playing that thing in the background while they are debating the things, does it really take away Laura Mathias' marketplace? Again, not a copyright attorney. Let us return to Hustler versus Falwell. The court has carefully considered all the evidence placed before in the light of the factors set out in Section 107. It concludes that the, quote, equitable rule of reason balances tilts sharply in favor of finding of fair use. Any other result would mean applying the copyright laws in an inflexible manner and ignoring fundamental considerations of fairness. The ad parody was a satire about Falwell. He was entitled to use it as he did. Exactly. The cease and desist is an instrument of attack upon the recipient. Any court that would find that this is copyright infringement should be reversed or impeached. Okay, Counselor, but do you have a case that is exactly on point? As a matter of fact, I do. In Online Policy Group versus Diebold, The Northern District of California held that, quote, fair use is not an infringement of copyright. This is a slight tilt from the more common fair use is an affirmative defense logic. The Northern District of California held that the copying of the copyrighted materials, Diebold email archives, was so clearly fair use that, quote, no reasonable copyright holder could have believed that they were protected by copyright. The court in that case held that a DMCA notice and takedown was defective, and that the sender was liable for material misrepresentation. In short, while this is not legal advice, I'd say that if you want to reproduce a cease and desist letter as an act of self-defense or criticism, you should be comfortable that the fair use defense will back you up. And if you are the author of a cease and desist letter, sorry. If you're a sorry, hold on here. Sorry, I have to cough up something. Mr. Jingles? All right, let's... and if... Sorry. Let's start here. And if you are the author of a cease and desist letter, don't write anything that you don't want the entire world to see. Bottom line, no court has ever held, I declare confidentiality to be valid. Nor has any court supported, don't make fun of me because copyright position, but an undisturbed case relying on mountains of precedents refutes it. So with that, here's a really stupid letter from Lena Dunham's attorney. It isn't just dumb because it tries the aforementioned tricks, but substantially, dude, really? You're supposed to be a better lawyer than that. Short version of the story. Lena Dunham wrote a book in which she arguably wrote about doing some sketchy crap with her little sister. Truth Revolt wrote about it. The quotes from the book back up the Truth Revolt article. Dunham got all snippy about it. Yeah, that was pretty fucking stupid. It's not stupid that she did it. She was a child, okay? I can live with that. It's not even stupid that she wrote about it. Respect to her. Okay, not really. Books sound like a piece of shit. But what the monkeys eating their own feces fuck was she thinking in authorizing a law firm to make a stink about it? Stupid! Well, unless they had a meeting and say, quote, hey, Lena, want us to totally fiddle fuck you by making you look like an asshole? Well, then, we got a plan for you. If that happened, then genius. This article constitutes confidential legal communication and may not be published in a manner. Just kidding. So, no. It's gone. Let's see here what we can find about. No, where is it? Come on. All right, let's do the... Lena Dunham responds to accusation that she did bad things to a younger sister. That's her. Grace Dunham tweeted the following response to the Führer a few hours later. Heteronormative deems certain behaviors harmful and others normal. The state and media are always invested in maintaining that as a queer person, I'm committed to people narrating their own experiences, determining for themselves what has and has not been harmful. And today, like every other day, is a good day to think about how we police the sexualities of young women, queer and trans people. lady, you wrote a book including molesting your younger sister. I don't think that has anything to do with queer and trans people. Unless you want to actually say that I'm allowed to do it because queer and trans. Seriously? Wow. Folks, I did not expect this. Kevin D. Williamson, columnist for the Conservative News magazine, and Bradford Thomas, blah, 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 have both accused Lena Dunham for admitting to essaying her sister. Delegations team from several passages, an actress recently published memoir, Not That Kind of Girl. In one excerpt, she wrote, "Do we all have uteruses? I asked my mother when I was 7. Yes, she told me. We were born with them, with all our eggs, but they start out very small, and they aren't ready to make babies until we're older. I look at my sister, now a slim, tough 1-year-old and a tiny belly. Oh, for fuck's sake. I'm not going to... Folks, I can't say these words on YouTube. For fuck's sake, you sick cunt. You absolute depraved motherfucker. Motherfucker. All right. Now I might be able to read the rest. Seriously. She then quotes the right-wing news story that I did bad things to my little sister isn't just LOA, it's really effing upsetting and disgusting. The Golden Globe winner told her followers Saturday. And by the way, if you were a little kid and never looked at another little kid's vagina, well, congrats to you. No! You sick cunt! For fuck's sake, no, people do not do that. Even if you were 7 years old, you know better than that. She says, and by the way, if you were a little kid, and usually this is stuff I can ignore, but don't demean sufferers. Don't twist my words. Back the fuck up, bros. I told a story about being a weird 7-year-old. You depraved shit. You're a rapist, Miss Lena Dunham. A 7-year-old rapist of your own little sister. For fuck's sake. And that is by your own fucking word. However, Dunham's defense only furthered the debate about whether she described molestation. And yada, yada, yada. Okay, this is way back from 2014. So it's 11 years ago. Is she still working, this cunt? Yeah, she does. Of course she does. She still does movies and TV. Folks, I had no idea that this was in uh in Randazza's, that the link led to this. I honestly had no idea. Oh, for fuck's sake. So, in my opinion, not only did she admit to rape, she seems to be kind of proud of it. Which makes me ask the question, how many more? Jesus Christ. And no, she wasn't cancelled, apparently, because it's different. Apparently, if you blame that you're not a heterosexual, Jesus fucking Christ. Okay, folks, I did not expect that one. I had. Wow. Statute of limitations is probably already gone. All right. I need something funnier to talk about. Let's see if I can find something fun instead. Which one is this? No, that's the same one. Dun, dun, dun. Dun, dun, dun. This sounds like fun. The Mormon Leaks letter. Where's the letter? Come on. Dun, dun, dun. Where is the... Sorry. Let me... Okay. Come on. Yeah. Okay, apparently. No. Removed. Darn it. Dun, dun, dun. Okay, let's try to find something else. No. Oh, for fuck's sake, come on. All right. It seems like it's... Let's see here. This one, maybe. For fuck's sake. Sorry. All right, let's do this one. This we already talked about in a prior video. But this is a good way to move on to the next subject I was going to talk about today. Laura Matthias. So let's get ourselves updated. Randazza Legal Group. Dear Attorney Dice, this firm has the honor and privilege of representing Redacted. We are in receipt of your cease and desist letter on behalf of Laura Matthias. This letter provides no specific about what Redacted allegedly did. Is it your regular practice to send demand letters that don't contain a single factual allegation? That seems pretty ineffective. Is my client coming to your client zone? Is my client in the house now? Can you show me on a doll where my client touched you? I mean, what even is this? Is this a mass mailing you just sent to everyone? Did my client accidentally fill out an index card at the timeshare presentation and he wins a free demand letter? You request that Redacted cease and desist from any continued harassment and dissemination of altered, AI-generated or private messages which you attribute to Ms. Matthias, which you claim violates Florida's wiretapping law, Florida Statutes 93403. You also claim that this unspecified conduct constitutes stalking or harassment under Florida Statute 784048 and 18 U.S.C. 2261A. I do not find any record of you being a member of the Florida bar. Accordingly, it is probably an honest mistake that you have misinterpreted Florida law, but I don't know. Florida law isn't that hard. You really whiffed it on Florida Statute 93403. This statute prohibits the interception of communications or disclosure or use of unlawfully intercepted communication, knowing they were unlawfully intercepted. Again, I don't know what the facts are here since you didn't provide any. But here's some good news. You don't have to provide any facts in order for me to extrapolate that the law just doesn't apply. Isn't that cool? Watch this. I see nothing. Oh, for fuck's sake. Let me bring it up. Where's the rest of it? You fucked up. Oh. I see nothing in your letter suggesting that Redacted or anyone else intercepted any communications by your client, by anyone else, nor any discussion of any fulfillment of the requisite mens rea. It's kind of weird how you could think altered or AI-generated messages that purport to be from your client could possibly have been intercepted, as your client necessarily would not have been a participant in such communications. So without even knowing the facts your client is reporting to you or you relied on in making this demand, I can tell you that this statute just can't possibly apply. That leaves the claims of stalking and harassment. Again, there's no information for me to go on. Just an assertion that Redacted is harassing your client. I'm left to guess as to the method of this harassment. Florida Statute 784048 defines harass as to engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. With course of conduct defined as a pattern of conduct composed of a series of acts over a period of time, however short, which evidences a continuity of purpose. The federal stalking statute you cite is similar. So look, maybe your client has some legitimate beef. If she does, then you kind of need to tell us what it is. Until then, I guess you can just keep sending letters that say, hey, cut out doing that thing that isn't really a thing until we say to do that thing. I mean, at least that would be funny. To conclude, we don't know what you're talking about. My client is not going to comply with your letter in any way, shape, or form, and we hereby demand that you stop doing something. You have to guess what it is, though, or you're committing a RICO violation. Govern yourself accordingly. Yeah, he's mentioning RICO because a bunch of Lauren's relatives are being sued about it's a case about, it's something about a house, foreclosure, selling, loans and stuff, and allegedly they made millions out of it, and the person they made the millions from is suing them. So that will be interesting. And with that, Laura Matthias. Let's see here if I can. Dun, dun, dun. Where did I put it? Hold on. I had it here. I promise you I had it here. We are all professionals. Now let's see. All right. Let's see here if I can get this one to work. Hold on. Yeah, Laura Matthias is accused of plagiarism. Isn't that interesting? She is accused of reusing years-old scripts in her own videos and knowingly doing so. Let me play this thing here.
Smith. Byron and his older
grew up with an older brother in a household marked by stability and encouragement. Both
brother grew up in a happy household, and they participated in the Boy Scouts from a very young age. Byron.
Jesus Christ, they play that fast. That's
older
grew up with an older brother in a household marked by stability and encouragement. Both
brother grew up in a happy household, and they participated in the Boy Scouts from a very young age. Byron would go on to become an Eagle Scout, which is the highest rank in the Scout system, an honor that only 4% of Boy Scouts ever receive. He became an avid outdoorsman and always wanted to make his parents proud. He worked hard to live up to his father's achievements.
Of Eagle Scout. The lessons of discipline, responsibility, and leadership stayed with him. Throughout his life, Byron's father, Ted, was a decorated...
Yeah, so what you're seeing here is the original. And overlapping is Laura Matthias talking about the same thing, word by word.
Army veteran, a man whose service in World War II.
Who was a decorated Army veteran serving in World War II as a pilot. During a raid in Germany.
During the raid over Germany, Ted's plane was shot down. He spent 19 months as a prisoner.
Bro, are you guys hearing this shit?
He was awarded a Rolex watch by the French government, recognizing his bravery and resilience.
Hold on.
his plane was shot down, and he became a prison officer of war for 19 months. After his release, he was given a Rolex watch by the French government for his service and time spent as a prisoner of war,
Wow.
which he would later pass on to his son Byron. Byron cherished this watch.
This watch would one day become a treasured heirloom for Byron, a symbol of courage and sacrifice he carried with pride. Academically gifted, Byron graduated second in his class from Little Falls High School. He went on to join the U.S. Air Force as an electrical engineer. For his
Need I continue?
Yeah, isn't that weird? Now, this video, I believe, is from 2022. And Laura Mathias did almost word by word the exact same script a few years later. Isn't it strange that Laura Mathias, who keeps sending out copyright claims, trying to strike channels, suing people, apparently does this little thing called plagiarism on her own material, in what she produces. Lauren, did you honestly think we wouldn't find out? Honestly. Did you actually believe? Because that original had over 1 million views. And you thought just because a couple of years have passed that you could simply do it again, word by word, and claim it as your own material. How can you be that lazy? How? How can you be that unethical? Fooling your audience into thinking, oh, this is a good explanation about this person, and you're just reading what somebody else did. I don't get it. Now, folks, you have seen me read from documents, but I fucking show you the documents. Here is what I'm reading from. I'm lost for words, but at the same time, I'm not surprised that this has been revealed. She fits the profile of a person who does not want to do the job, but wants to take credit for it. And always playing the victim when caught. And now, apparently, plagiarizing a 2 to 3 year old video. And she doesn't care. But at the same time, we know from the Delphi case how she and her supposed sidekick, the Peter Griffin lookalike, they didn't care about the truth there either. They saw a chance to make easy money by supplying their viewers with a false narrative because they knew it would make them money. Now, counter argument, Nick, aren't you making money out of this? Folks, if I wanted to make money, I would work more. This here is a hobby, what I'm doing here, content creating, and on a real, I believe the last year, If you go back 365 days, my absolute best day, I made $600. And oh boy, that was a lot of spins on the wheel of regrets. And it was a fundraiser, by the way, if I recall correctly. And usually I'm at like 40 to 50 bucks per day. Seriously, I don't do this for the money. It's a what I love when you sponsor. I love that you are members, that the occasional super chat comes in. And what do I do with it? I go to the United States and I do some content from there. That is what you're getting for your money. And that is what now, of course, I about $350, $400 a month. That is what it costs for me to run this channel. Anything surplus, I do things with. Going to the United States, visiting courthouses, visiting places, visiting people, doing hangouts. I mean, even if I went broke even on this, where I only got in what I put in myself, I would do it. And it gave me this have given me the platform to do fundraisers for the Rick Allen Appeals Fund, for the Rick Allen expert, when he needed experts in his trial, for the Zachariah Anderson Appeals Fund, for Aaron Spencer, Ian's fundraiser for sick kids, stuff like that. It gave me the platform to do that. And I'm happy doing it. Folks, I'm doing okay with my line of work. I'm doing okay. I'm not rich by any stretch of the imagination, but I do okay. And you guys who are here, if you came here and thought there's something wrong, you would fuck off and none of the fundraisers would amount to anything. And that, I believe, is the difference between when, for instance, me, Baker, and other people, when we jokingly call ourselves grifters. Laura Mathias is, in the old sense of the word, an actual grifter. She does not care as long as she can make some money. Apparently, using other people's material or just being a government stooge. Giving people who are thirsty for blood the blood they're searching for. Oh. So yeah, Lauren, I don't know if you watch this. I don't really care if you do or don't. You wanted us to stop talking about you. That's not going to work because you do stupid things, unethical things. And in this plagiarizing case, yeah, that's a civil suit in the making. I don't wish bankruptcy on many people. But Lauren Mathias, or if anybody, of all the people that are kicked off YouTube, kicked off the monetization, I think you and Hidden True Crime actually deserves to be demonetized. For you to be exposed as the grifter You really are. All right, folks, we are closing in on 2 hours. I don't see that I have any guests in the making. So, and you got, I mean, we have $40 from the next spin on the wheel. So if you manage to get in $40, we will talk about something else. I would find something cute to talk about. But unless in the next 7 minutes, the the slightly buzzed Friday Law Show. Let's grab myself another beer. See what I got here. Paulaner Weissbier. I don't always only do dark beer. Sometimes I do Weissbier. Dun, 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 dun. Now, Hidden True Crime has, what is it, over 300,000 subscribers. And I'm nowhere near that. I'm again closing in on 20. I have currently 19,920 subscribers. So I need 80 more for 20. Now, the celebration I had planned is not until 25,000. And we will see if we get there and when we get there. Other than that, what is coming up? Of course, you have Santa Claus. Every December, I turn into Santa Claus, where my studio part of the farm gets more and more Christmassy. And of course, we are approaching the actual Christmas, where I will hold, where we will do the A Muddy Christmas. Jeff, Legal Vices, started that tradition that every year one stream should be for our moderators. And I will facilitate this year as well. Now, the date is a bit unclear. It will happen somewhere before or after Christmas, A Muddy Christmas. Then we are closing in on the 3-year anniversary of this show, of this channel, which I believe is December 28th, 3-year anniversary. Other than that, let's see here. Well, we had the Karen Reed case will be ongoing. Let's see. I know that in Florida, the grand jury in the county where the Adelson case is situated, they have meetings now in November. So we will see if they are actually going after the rest of the Adelson family. What else do we have coming up here? The Natalie Green case will be interesting. The woman who mutilated herself and tried to blame anti-Trump. Brian Walsh trial should start next week. And I will do as much as I possibly can to stream that live, that trial. So that is what is going to happen in the nearest future. Yeah, thank you, Becky. Monday, start for Walsh. Now, I'm with all the shenanigans, because in the Brian Walsh trial, we have the Karen Reed investigators claiming they have everything figured out. But Brian Walsh, his attorneys, made a brilliant move by him pleading guilty for deceiving the police officers. Which means that part of the trial is done. Which means the prosecution is very limited to what they can bring to the jury regarding the murder of Anna Walsh. Okay, folks, closing in on the 2-hour mark. Thank you to you guys. Without you, this channel would be nothing, and you guys are making it something. But that is the Slightly Buzzed Friday show for you. 2 hours this time. Let's see, maybe 4 hours next Friday. Or 1 hour. No, 2 hours minimum. Always 2 hours minimum. Everybody, have a glorious Christmas season. And I hope I can do my part in making it a little bit better by providing a scenery of Christmas while doing horrific trials. You all have a great weekend. And yeah, I will see you all in the next stream or video. You all have a good one. See you. Bye.
Nick the Viking lawyer's got a brew in hand, streaming wild cases across the land. A courtroom circus, a legal ride, slightly buzzed on justice and a Viking's pride. Objections flying, gales a swing. Nick just laughs, oh, what a thing. It's a Slightly Buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare. Mugshots rolling like a movie reel, a pizza thief or a banana peel. He calls it absurd, he calls it wild. Your Honor, is this trial on trial? Raise your glass to the streaming king, a Viking lawyer with a legal zing. Don't sue me for fun, I'm here for the lore, and maybe one more drink before we explore. It's a Slightly Buzzed Friday lore show, where the weirdest trials steal the show. Nick's got the verdict, he's got the flair, with a horned helmet and a lawyer's glare.